Well, Barnet was me. I'm a sole trader. I spent a number of years as a financial advisor many years ago, and really when I would do reviews for clients, I would say to them, have you got a will? They would say no, and I would say go off and see a solicitor and make sure it's sorted out. And at the next review, I would ask them, did you make a will? The answer would be usually no. So in the end, it was time to actually decide, to make sure they did it. It was for me to do it myself. So that's what I did. And really, when regulation came in, I didn't like the way financial services was going, and I decided to concentrate on the wills and the estate planning full time. And that's really, Barnet was because I'm based in Barnet. That's really how it all started. Well, the main reason is if you don't have a will, the government make one for you, and it doesn't necessarily follow that your wishes will be honoured. And probably one of the most important reasons, particularly for people who have children, is appointing guardians. Because if you want someone to look after your children, if you don't have a will to specify who that person would be, then the courts will actually decide who would look after your children, and that may not be the person that you chose. The courts could take weeks or months to make a decision. They could even actually put children into care while they're making that decision. So you can imagine that if your wishes are completely ignored, you have no say, so your money and your children could end up in places where you didn't want. So that's why it's very important to make a will. You have to have an idea of what you want to happen. There are templates and will kits that you can buy in WH Smith. I've seen many of those go wrong. But you need to actually have an idea of what your estate is and where you want it to go. And then either try and do it yourself or appoint a professional to make sure it's done right. What people don't understand is that a will is just a document or an expression of wishes. This is what I want to happen if I die. A will doesn't have any flexibility or any protective powers. So very often, even with a will, your money could end up in the wrong hands. And that's really what estate planning is all about, and what Barnet Wills is all about. It's not about having a will, it's about having the right will. Yes, I do a lot of work with business owners. There are a number of issues. First, the most important one, it depends on the nature of the business. If it's a business that's trading, that has stock or premises or business assets, then it's very important to have a will that deals with those assets specifically, because it might be that the business qualifies for something called business relief, or used to be called business property relief, which is a relief against inheritance tax. So you can actually pass your business assets free of inheritance tax. The other issue is if you've got business and you've got business partners, if Director A or Partner A dies, then Director B is now in partnership with Director A's spouse. Now, she may not be able to contribute to the business, she may not, she may be able to take your money out without making a contribution, she may want to sell. So it's important that you have things in place to make sure that those sort of concerns are looked into. Simple wording, I leave £5,000 to my grandchildren. Is that 5,000 each, or is that 5,000 split between 7 of them? Without specifying exactly how it's done, the executors don't know what your intentions are. Very often they're not executed correctly, which means that the signing and the witnessing hasn't been done correctly, which means that the will be invalid and you're back to intestacy. I've seen where witnesses are beneficiaries in a will. Now, a lot of people think that if a witness is a beneficiary, it'll invalidate the will. It doesn't. It invalidates their inheritance. So if you're a beneficiary under a will and you act as a witness, you've actually disinherited yourself. So, these are sort of things that I come across quite regularly. From a business point of view, the pandemic has certainly focused people's minds on things that are happening out there. So I've seen quite a dramatic increase in inquiries and in business, where people are wanting to put their affairs in order because someone they know has had issues or died or so on. So it has certainly raised awareness for the need for wills and for planning. For a simple standard will, I charge £155. For a couple, it's £255. And when I say a standard will, that would be everything from the spouse to the surviving spouse, and then to the children. And there's usually a mirror. But there are risks to those wills. You know, what happens if you die and your spouse remarries? All your money goes into that new relationship. If your wife were to die before the new husband, he's now got all your money and can disinherit your children. That's probably one of the most common ways people lose out, because there are so many people in their second or subsequent marriage. A lot of people lose their house to care fees. You know, if you die and your wife requires care, if you haven't got oodles of cash in the bank, the local authority will come after your house and they'll force it sell to cover your care fees. You leave your money to your children, they go through a divorce. That's half of your money walking out the door, you know, with your ex-son-in-law or your ex-daughter-in-law. You know, there's another pandemic, they have issues with creditors or bankruptcy, inheritance tax. So these are all sort of things where a will on its own has no flexibility or power to protect against that. So if you need further planning, that's where some of the additional costs come in. But I would give clients, everything I do is on a fixed fee. So I'd advise clients what the fees are going to be in advance, and they can decide, I want a simple will, or I'm really worried about, you know, my gold digger, you know, my daughter's gold digger boyfriend. I want to make sure that they can't come after my money. Which case we're now talking about getting involved in things like trusts and so on, and further planning. But the cost of not having it is far greater. So let me give you an example. Okay, so I'll tell you a story about a couple called Arthur and Jenny. Right, they have been married for about 40 odd years. They have two grown-up children, Mark and Andrew. Mark is married to Alison. Now, when Jenny got into her late to mid-40s, she developed dementia. And unfortunately, by the time she got into her mid-50s, it had gotten so bad that Arthur decided to take early retirement and look after her full-time. Sadly, he had a heart attack about a year later and died. So under the terms of his will, everything passed to Jenny, right? Now, the estate at the time was about £750,000, right? But most of that was the family home, right? Now, the two boys, obviously, they couldn't give their mum the same care and attention that Dad had done, and so they made the decision that the best thing for her would be to go into a residential home that specialised in dementia patients. And that's where the problem started. Because there wasn't a lot of cash in the estate, the local authority forced the sale of the house to cover Jenny's care fees. So by the time she died about 4 or 5 years later, only £360,000 remained. Right, so over half the money had been spent by the local authority. So the boys inherit £180,000 each. Right? Within 7 months, Mark waved bye-bye to £90,000 because Alison was divorcing him and she took half of everything, including half of his inheritance. Andrew wasn't so lucky, because Andrew had a business that was in deep trouble. He was in debt to the tune of nearly £250,000. So as soon as his creditors found out he had this inheritance, they were all over him. So he ended up with absolutely nothing. So despite having perfectly drafted, beautifully written wills, only £90,000 out of Arthur and Jenny's £750,000 estate ended up where it was supposed to. That is just 12% of the estate, right? The other 88%, £660,000, was lost to people that Arthur and Jenny didn't intend. You know, the local authority, an ex-daughter-in-law, and you know the banks and the creditors. Okay, so they are probably rolling around in their graves cursing the solicitor or the will writer that drafted those wills. Not because he lost them 660 grand, which he did, but because they weren't even made aware of the risks. Had they been made aware of the potential risks or threats to their money, they'd have had a fighting chance to protect it, and actually all that could have actually been avoided with the right planning. And Arthur and Jenny could have left everything to Mark and Andrew, and Andrew wouldn't have lost anything in a divorce, the local authority wouldn't have got their hands on the house, the banks wouldn't have got any of Andrew's inheritance, for his debts. So that's really what estate planning is all about. It's really making sure that your money ends up staying in the family where you intended. And it'll go from you to your children, to your grandchildren, and so on, and it can't be lost to third parties, people that you don't want to have their hands on your money. Generally speaking, I would say that whenever there's a major change in circumstance, marriage, divorce, buying a house, having a child, something like that. If those things don't happen every 5 or 6 years, just to make sure it's still, sometimes you might get an inheritance from your parents, so, suddenly there's this influx of cash because you've inherited money from family or from parents. That means that you've now got an inheritance tax liability that you didn't have prior. So yeah, either when there's a major change in circumstance or every sort of 5 years or so, just to make sure that it's still right for you. Okay, so a will deals with your affairs after you die, right? Powers of attorney deal with your affairs while you're alive, but don't have or capacity or can't manage your own affairs. Now, incapacity can be temporary or permanent. So, for example, I had a client, Mary. She had a stroke, and as a result, was in a coma for about 4 months. During that time, the family asked the mobile phone company to cancel the contract. They wouldn't. They asked the banks to cancel some redundant direct debits. The bank refused. She actually had private health insurance, and the family tried to claim on that, and the insurance company wouldn't deal with them. None of these institutions were doing anything wrong, not contractually and not morally. They all said, look, we can't give anyone access to Mary's accounts without properly documented permission. What people don't realise is that if you lose capacity to manage your own affairs, nobody has that right. Not a spouse, not a child. In this context, next of kin does not exist. Right? You'd have to go to court, or your care package will be determined by the doctors and the local authority, and very often they don't actually involve the families in the care package. So power of attorney are documents that you choose who you want to manage your affairs if you're not able to manage them yourself. And there are two types. There is one called the property and finance, which is a money document that allows your attorney to deal with all your finances, pay your bills, run your bank accounts, deal with claims, benefits, insurances, collect money that you're owed, pay money that you owe, and so on. The second one is the health and welfare, which deals with the medical profession. So that's allowing you attorneys to make decisions about your medical treatment, where you should or shouldn't be treated, your diet, your routine, right through to a do not resuscitate, a life-sustaining treatment order. So without them, you're leaving your fate in the hands of strangers. And if you don't have them, the only option that your family or loved ones have is to go to court, to the Court of Protection, and get what's called a deputyship order. And that is a nightmare. It is a nightmare financially. It is a nightmare emotionally. It can take over a year to get an order through. And the average cost is somewhere between up to about £4,500 to bring an application. And that's not, paying solicitors to do all the work in helping you. Well, it's a myth that look, if we had a crystal ball and we knew when our day was up, yeah, we could do it 2 or 3 weeks before, but we don't. So it's better to do it. There's this myth, people think that if I write a will, I'm going to die tomorrow. There's this, I'll get around to it at some point. It's just, take action. It's important. I'm still surprised that so many people don't have even a basic will in place. It's something like 70% of you adult Brits don't have a will, let alone the right will. So it's just get advice, get it done, have peace of mind, and then you can forget about it.